Thank you. We'll move on to our last case and our civil case, so the attorneys can come up and get ready. Minutes per side on this one, so.
Thank you very much. May it please the court.
Okay.
Your Honors, my name is Chris Carlisle. I'm here on behalf of Thompson Hills Estates. I'd like to reserve 5 minutes for rebuttal, please.
Okay.
Your Honor, this case comes to this court in somewhat of an unusual posture in that we're talking about a motion in limine that prevented any evidence being presented concerning the severance damages that Thompson Hills claimed it was entitled to under the Florida Constitution. In essence, the court granted a de facto summary judgment which prevented them from putting any evidence on before a jury that they were entitled to concerning the damages that were sustained. There are two main issues that this court has to confront. One was raised for the first time in the answer brief. It was not raised below, obviously, and that's the position taken by the other side that this is a matter for the trial judge as opposed to the jury, a position that no case in Florida has ever taken prior to, or has ever taken. And if we look at the brief, and we see what they're attempting to argue.
You would agree that if the parent tract issue can be decided by the trial judge in this case, I mean, put aside the issue that you're about to talk about,
Yes.
Then the trial judge's decision, I mean, it wasn't wrong to decide it this way, right? I mean, if
Certainly it was, yeah.
What?
It was wrong to decide it this way, yes.
I mean, you're saying that you have to file a motion for summary judgment before you can file a motion in limine? Is that
I'm saying that if you're taking away someone's right to seek damages for an eminent domain proceeding, something more is required than this. I'm not suggesting that in a certain case, under extreme facts, that perhaps a motion in limine would be appropriate, but here the facts were obviously disputed, and you don't have platting. We're looking at the three factors that we're talking about.
What I was trying to say is, if this were one of those cases where you would even agree that the trial judge could make the decision as a matter of law.
Is it conceivable in a certain case that this? Yeah, it is.
Okay. And you do agree that what the parent tract is can in some cases be decided by the trial judge? I mean, all the cases you cite say that it's usually a decision for the trier of fact, without really saying who that trier of fact is, but...
You have to recognize also that there's a difference between eminent domain proceedings when you're entitled to a 12-person jury, and also regulatory cases or inverse condemnation cases that are tried before a judge. And so some of the confusion, I think, comes in here about the trier of fact and who that is in determining the parent tract. This court in Blankenship recognized that distinction, and I think there's some confusion from the other side that is being brought about here, trying to say, well, gosh, we have some cases where the trial judge says the trial court made the decision. Well, yeah, it was a jury. It was a bench trial. And the cases that we're talking about where we have an inverse condemnation case, specifically Middick, which is by far the most compelling case before this court, and then this court's decisions.
Let me ask you about the three factors. The first factor, the unity of ownership.
Yes.
Is that really a factor that you weigh, or is that like a requirement? I mean, you can't go in and get... Say that your client only owned the 10-acre or so parcel that's zoned commercial in this case, and then somebody else owns the PUD property.
Right.
That person couldn't come in and say, I want severance damages. I mean, ownership's sort of a requirement, right? I mean, it's not something that you sort of factor into the equation. If you're not the owner, you can't claim it's part of the parent tract, right?
I think, again, that obviously that's a factor that's considered, but but speculating on potential ownership issues, I mean, I think if you look at this court in the Canaveral Properties case, it said there are 4 different owners. This obviously, and the trial court allowed it to go forward, and it said, to a jury, by the way, and said, we're going to take that away because this obviously, you've gotten tax benefits from different corporations for this property, and there isn't unity of ownership, and the facts are so extreme. Is there a conceivable case that the ownership could be separate, maybe owned by the same sub-entities of a parent corporation or something? I don't know. But in this case, unity of ownership is obviously not disputed. And to hypothetically say...
You own a 10-acre tract, and I owned
Right.
The other tract. I couldn't come in and say, wait, this is a parent tract. I mean, there's no claim for severed standards.
Again, I just on that extreme hypothetical, I don't know. I mean, I would say probably not. I would say probably not, but again, there are situations that they could be owned by separate entities, what I'm saying, that maybe are owned by a parent corporation. There could be some reason to go beyond that. And we don't just look at unity of ownership, and the Supreme Court didn't say if there is in fact separate ownership, that ends the inquiry and we're done. It says it's one of the factors that we're considering here. And we're also looking at contiguity of use. And so we have the two factors that the court lays out first that are undeniably in our favor.
If the property had been developed in accordance with the zoning, would you agree that this was an issue that the trial judge could decide? In other words,
No.
No. So, I mean, you make a big deal about the fact that this is vacant land at the moment.
Well, there are several reasons for that. I mean, number one, we have to look at...
Your argument really is it's always a question for the jury.
Not always.
Not always. I haven't been able to find, even if I own the part of the property, I can still come in and argue to the jury apparently.
Again, Your Honor, these are factual determinations, and almost in every case, and there are certain cases, and we've cited them, and they've cited them, where...
I've never seen one.
No, I've seen cases, and there are cases where, again, including this Court's Canaveral Properties decision that says, yes, it was a jury issue, it was presented to the jury, and there was insufficient evidence, and a directed verdict should have been granted. That doesn't change the fact that you get it in front of the jury, which didn't happen in this case. Yes, there are extreme cases. There are cases that the Court can come in and say, based on the evidence that was presented at trial, you didn't carry your burden, or you didn't rebut the presumption. I'm sorry, Your Honor.
A case like this where the owner seeks in a PUD that contains, according to my notes, residential components on the north and in the southern portion, and commercial uses on the northern half, and then the 9.9 acres is excluded from that request. And the 9.9 acres is located on the southern part, where there's going to be in the PUD area, residential uses, and the 9.9 is zone commercial.
Correct.
And that's not...
It's not enough. And
You don't think that's it?
No, I don't, and I'll explain why.
Well, how could there be a unity of use there, then?
Because the owner, this was all undeveloped. There was discussion below that said they were attempting to use this to market it all, and having the residential area flow into and support the commercial area would aid in the marketing of the entire parcel. There was evidence, or there was discussion, that the commercial area was going to be bisected by a road going into the residential area. There was evidence that, or there was discussion, far from evidence in this case, that there was going to be landscaping that was consistent throughout. There was going to be lighting that was consistent throughout. The person putting this together and attempting to perhaps sell this as a whole...
If that's the case, why was the 9.9 left out of the...
There was no need to have it be part of the PUD.
Zone commercial classification, which is certainly incompatible with the southern part of the PUD property that has a residential component to it.
Again, I would disagree in the sense that if you're trying to market this entire property to someone else, this is not developed yet. It's not separate. It's not, you can say you're buying the whole property, and your commercial area, which is bisected, and residents are passing through it to get to their homes and are going to support the commercial use here. I'm selling this entire parcel to someone, or I'm going to put it on the market for sale in that way. There's a unity of use saying that this entire property that we're having here is, in fact, there was a reason for this. But the point is, Your Honor, also going back to the point, if we're going back to Jurek, we have unity of use, we have contiguity, we have unity of ownership, we have contiguity, and so use is the other issue. And what does Jurek say? Jurek deals with platted lots, not with undeveloped property.
What is the main issue in this case? Is it use, or is it ownership? It can't be ownership, because...
They've admitted that we have ownership and we have contiguity.
It's use, right?
It's use, yes.
And the trial court looked at it and said, because of the PUD request, and the way the PUD was set up, and the 9.9 acres was excluded from that, the 9.9 acres is zone commercial, the southern part of the PUD property is basically going to be residential. And so it seems to me to be reasonable for the trial court to conclude that, I mean, the uses are just different here.
There was expert testimony from the appraiser on this. Well, again, let's go back to the Middick case that, again, was decided 25 years ago. And it talks about where you have unity of use, you have, unity of ownership, you have contiguity, and you had 9 different platted lots, which Jurek says creates a presumption that there is separateness. And that issue went to the jury in that case. There were buildings on certain lots. There were 2 lots that were used for a...
Why wouldn't you have that same presumption when there's no factual dispute as to the intended and permitted use of the property? I know it's not platted, but...
The intended use of the property by the person that owned it was to sell all of this as a whole potentially to someone, including the commercial area, and that was the point of it. It was the question of the intended use, again, is a factual issue. And we're not even getting to the...
There's no factual issue. I mean, the trial judge had all the information about the intended and permitted use of the property, and there was no factual dispute about the intended and permitted use of the property. It's just this question of, well, is that one use or 2 uses, really? I mean, which...
Again, I disagree. The point that I think I'm hearing from you and for the other side is taking is that by zoning a certain area differently, that you ipso facto, no doubt, as a matter of law, can never have a unity of use with other property. No case says that. No case says that. They say if you plat them, a presumption arises, which you still get to go to the jury and attempt to put on evidence to rebut. That's what Middick said. Middick said, obviously, it was appropriate for them to be able to present to the jury evidence concerning that to overcome this presumption. We don't even have that presumption here.
Why didn't they include the 9.9 tract into the...
Because there was no need at the time. It was already zoned. There was discussion that the tract tables of that entire PUD included that acreage. There was discussion about all the plans for the road that were going to be changed and configured to make this be coordinated with that area. There was discussion they were going to market the entire thing together as one thing and sell it to someone. If those aren't factors that can do this, what you're saying is something zoned separately is always, ipso facto, never a doubt about it, going to be separate, and you're ignoring Jurek, and you're ignoring cases that say it's a factual determination for the jury.
It depends on how the zoning came about and when the zoning requests were made and all of that. Here it came about because there was a specific request, I forget, was it 100 and some acres that was included within this PUD unit, I'll say.
114.
Okay, 114 or whatever. And then that specifically excluded the 9.9, which was zone commercial, and then the southern part of the PUD unit, it was basically residential. And so this doesn't make sense that you're saying that there's unity of use there when...
Your Honor, again, with all due respect, to suggest that if I own this property and I'm going to attempt in the future to sell both the residential and the commercial parts together, and I'm going to market it that way, and I'm going to say, you, Mr. Buyer, can have this property that has a road bisecting your commercial area, that's landscaped the same, that has the same street lights, you're using this, why am I not saying at this point, when it's undeveloped, it's not platted, there's nothing there, why can't that be unity of use? Why can't you say that the unity of this thing, this entire project...
You're basically saying it's just a jury issue and then the trial...
I'm basically saying that even if it was platted, which is what Jurek says, you still have a jury question on unity of use. Here, you don't even have the presumption arising from platting. And you have, again, if to adopt what they're suggesting is to say that the one factor, ignoring the 3 that are set forth in Jurek, ignoring the other factors that are in other cases, the one factor of zoning is it. And that does not, nothing says that. That's contrary to Jurek, and that's not the law.
Well, statement that the intent was to market the entire property.
There was some discussion of that.
The entire property, meaning the commercial plus the southern portion of the PUD or the whole PUD?
The commercial and all of it, or potentially, the discussion before the trial court.
Where did the distinction come to say the parent tract only included the southern part, not the entire, if your argument is you look at what the intent was, and the intent was to try and sell it all?
Because that was the appraiser's opinion. And again, we could...
The basis of distinguishing the southern part from the rest?
The basis was that the property narrowed, and he, in his opinion, based on the way this was... And again, there was not necessarily... The intent was, we have all this vacant property. We now have some flexibility with these different things. We can sell portions. We can sell it all. We can do different things. We don't know what we're going to do yet. But, and again, I don't know that they should be penalized for their appraiser trying to be reasonable and not seek severance damages for the entire 114 acres. He came in and said...
It's not a matter of being reasonable. It's a matter of determining which factors go into defining the parent tract. And if your position is one of the factors that goes into defining the parent tract is whether they intended to sell it all together, then that would be an argument for the whole tract, but not for the southern part of it.
Well, again, the testimony was, or the intent was, that we want to have flexibility. We might sell it all, we might not. The appraiser rendered his opinion. Your Honors, again, I think that if we want to get in, just let me, I'm running out of time, and I want to save 5 minutes. I want to touch on the other argument. Middick Realty, again, is a critical case here that we're talking about, where even though it was platted, even though the presumption arose, the court in the third DCA used the word obviously. Obviously, they had the right to present this expert testimony to the jury regarding unity of use, even with separately platted lots. For you to find otherwise is to say that the distinction made in Jurek about platted lots and a presumption arising essentially is meaningless, and we're going to say that zoning trumps platting, which obviously it shouldn't, and we're not going to allow expert testimony on this issue. And finally, the court's aware of 2 other cases from this court, which I mentioned briefly, the Canaveral Properties case, which did find it was a jury issue, obviously, and then the Blankenship case, which Judge Palmer, you concurred on, where it was sent back and said it was reversed and remanded for a factual determination of the parent tract in that case, and it was a flooding case. And so, touching on the second issue very briefly, or the first issue perhaps, there is no basis for the issue of this being purely a trial court determination. It is a factual issue. Jurek, in the footnote that they're relying on, doesn't say that, and no court since Jurek, including this court and including the third DCA in Middick, has ever said, by the way, this is purely an issue for the trial court to consider. I understand the arguments that, or the question, I'm assuming you accept that, but the question then becomes, can a trial court ever make this determination? And again, I agree with Judge Lawson, it's conceivable, but certainly not in this case. Certainly not when you don't have platted lots, when you do have unity of ownership, and you do have contiguity.
How do you explain the footnote 6 in Jurek?
Footnote 6 in Jurek says, although the Seventh Circuit has found that it is, and there is federal law that says the trial court does make the determination. I don't know if I can explain that footnote, but it certainly doesn't say this is a matter for trial courts to decide exclusively. And in the 27 years since that case has been decided, nobody has ever read that footnote to stand for that. There's not one case that does that. And Middick finds exactly the opposite, and this court, which cited Middick in Blankenship and in Canaveral Properties, seems to agree with the position that it is, in fact, a jury issue. And when you have a constitutional right to full and fair compensation with a 12-person jury, taking it out of the jury's hands and saying a trial court can decide this issue on a motion to limine with zero evidence presented to it, I think is a stretch. I'm going to yield the rest of my time.
Okay.
That's all right. Thank you.
All right, thank you.
Good morning, Your Honors. May it please the Court, I'm Steve Brannick of Brannick & Humphreys here representing Progress Energy. We think the Court should affirm for 2 reasons. First, the trial judge makes the call, not a jury, and so the trial judge got that part right by making the call. And secondly, the trial judge got it right.
I don't see how we can reach that legal conclusion without going on bonk and dealing with the 2 cases that they cited.
Well, Middick is
It seemed to be opposite to what you're trying to argue here.
not at all. First, Middick is a 3rd DCA case. It's not a 5th DCA case. And the Blankenship case, which is the only 5th DCA case, doesn't say that the jury is going to decide the issue of the scope of the parent parcel. All it says is we are remanding back for a jury trial, and the scope of the parcel has to be determined, but the court does not say that the jury decides or the judge decides. It left that question open. But
it didn't seem to leave it open. It cited to the 3rd DCA case favorably, which pretty much said that, and then it certainly implied that that would be a jury issue.
Well, respectfully, the Florida Supreme Court has already decided this issue. So, but let's start one step back and start with the statute.
That would make it easy. Where did they decide it? You're talking about footnote 6?
In the Jurek case, yeah, footnote 6. But let me just kind of start at the beginning with the statute. The statute says that the jury shall decide.
How do you explain the fact that that seems to have been ignored? I mean, if the Supreme Court put this issue at rest, it sure isn't obvious in looking at cases
I certainly wouldn't. I mean, I would.
In the 25 or so years.
It certainly hasn't been ignored. A judge decided the issue in the Jurek question. A judge decided the issue in the Mulkey case. The judge decided the issue in the Brevard case out of this district, in the Niles case out of this district. A judge decided the issue in the Jupiter case out of the 4th. A judge decided the issue in the Riviera case out of the 4th.
And which of those are condemnation cases as opposed to inverse condemnation, or?
The cases that are in our context of the Mulkey case out of the 2nd DCA, that was decided as a matter of law in a severance case.
Which was a jury case? There was a jury in that case?
The judge decided the issue of the scope of the parcel.
Was there a jury in the case, or was it a non-jury trial?
It was the judge decided the issue before it went, I frankly don't recall whether there was a jury in the case.
Isn't
but
that
the judge
significant?
decided
I
that
mean,
issue.
if it was a bench trial, the fact that the judge decided it is no precedent for the fact that we should let judges decide it in a jury case, is there?
There are two reasons that judges decide it. One is the statute tells us that judges decide this question. It says that the jury shall decide solely the issue of compensation. Now, the federal courts, interpreting almost identical federal rule, have unanimously held that that means that judges, not juries, decide the question of the scope of the parent parcel. Then the jury case out of the Florida Supreme Court cited specifically to that federal precedent and the statute and said that although this is a question of fact, this is a question of fact that is decided by trial judges, not by juries, specifically citing to that similar federal precedent. And there is nothing ambiguous about the jury case, because in the jury case, the issue of the scope of the parcel was first decided by the trial judge as a matter of law. Secondly, it was then decided by the third DCA, who affirmed the trial judge as a matter of law. And finally, the Florida Supreme Court weighed in and affirmed the trial judge as a matter of law.
So your position is just polar opposite. The opposing counsel's position is that it's always a matter of fact for the jury to resolve whether this parcel is included in the parent tract, and your position is that it's essentially if it is a question of fact, it's something that the trial judge decides before it ever gets to the jury.
Absolutely.
So two polar opposite positions here.
And it was so obvious that that's what Jurek says that y'all didn't even bother to argue that below, interestingly, it doesn't look like.
Actually, Your Honor, we did argue that below. The motion below was entitled Motion in Limine to Determine Scope of the Parent Parcel. That was a motion designed to ask the judge, as a matter of law, to determine the scope of the parent parcel.
You wanted to keep the expert from testifying. You wanted to keep the expert out, right? I mean, it could have been because he was maybe trying to use some sort of reasoning, but you wanted to keep the expert out. That was the basis of your motion in limine.
The basis of the motion in limine was that was asking the judge to rule as a matter of law on the scope of the parent parcel.
But it was because your argument was that there's just no issue in this case because the intended and permitted uses are so clear from the zoning that they just got, right? I mean, it wasn't that this is always an issue for the judge, so here, decide it.
Well, both, Your Honor. I mean, clearly the focus of the motion in the trial court was, Judge, you can decide this question because as a matter of law, there's really no dispute about the facts here.
Right.
And rule for us. And that was, I mean, and that's a point that I'm making here as well. I say there's two reasons that judges decide these questions. One is the interesting question of judge versus jury. We think we're right. If you read Jurek, look at the statute, look at the federal statute, look at the federal precedent. That's one way to reach this conclusion. The second way to reach the conclusion is what you just alluded to, Judge Lawson, which is that in most of these cases, the facts really aren't in dispute. And there's no facts in dispute here. We know what the zoning is on the 10-acre parcel to the south. We know that the planned unit development...
But they say it was their intent all along to market and sell this as one big unit. So that's a factual dispute, isn't it? Now I'm confused because you seem to be saying that there are no disputed issues of fact then the trial judge can resolve. But I thought your position before was whether it's the parent tract and what encompasses the parent tract is always a fact for the trial judge to say, never the jury.
I'm making both points. My first and primary point is this is always a matter for the trial judge, whether or not there are
So are there any circumstances where a jury should determine what encompasses the parent tract?
No.
No, never. Okay.
But I'm saying that if you were to
And we're talking about condemnation cases here, right?
Right.
All right.
All right, Jurek is absolutely clear on that. But I'm saying that if you disagree with me on that point, you don't even need to reach that point because you can reach the second, perhaps easier point, which is that there simply are no disputed issues of fact here. We know what the zoning is, we know what the PUD is, we know that the PUD did not encompass the property to the south. So you can rule as a matter of law, just as this court reversed the trial court who let this decision go to a jury in the
And
Brevard versus
their
Conagra case.
argument that the testimony was that it was our intent to market this all as one big parcel, and it didn't matter whether the 9.9 acres was included in the request for the PUD, that doesn't matter. Our intent was, it was all going to be marketed as one big parcel, and you don't think that constitutes an issue of fact, that if we take your second argument, that would have put it over to the jury.
But frankly, that's not what their experts said, and that's not what they argued below. Their expert said that we're either going to sell this as a whole parcel, or we're going to sell it in phases. They reserved the right to do either, and their argument in the trial court was the same thing, that they might sell it in phases, they might sell the whole property. Now, if they were standing...
That's an intent what they might do. I mean, it doesn't necessarily have to, I mean, they have the right to decide what to do with their property in any manner they want, as long as it's a lawful use and a lawful purpose, right?
Well, absolutely. But there is a unity of use. If these parcels had the same use and had to be sold together, like the three parcels in the Jarrett case, if they had to be sold together, yes, then you might be able to find that unity of use. But here, because they have the option of selling them separately or the option to sell together, that's another factor that suggests that there's not unity of use. And so we seem to be shifting to the merits, and let me get to the merits of this case here, because I think that this case is exactly like the Jarrett case. In the Jarrett case, the court says that when you're talking about undeveloped property like this, the most important factor when you've got is the unity of use. And in the Jarrett case, the court decided there were three separate parcels and not one, because the owner had gone through the trouble of platting the property, had gone through the expense and the time of getting the regulatory approvals in order to separate the properties. And the court said, and under those circumstances, that's very strong evidence that there is not, in that case, that there is not unity of use because of the effort that was undertaken. And the point that the court was making...
Very strong evidence isn't the same as a matter of law, though, right?
Right, but the court then decided the issue as a matter of law. The trial court decided in Jarrett, the third DCA decided in Jarrett, and the Florida Supreme Court all decided the case as a matter of law because the intent of the owner was so clear by obtaining those regulatory approvals. And I think it doesn't matter that we're talking about platting in the Jarrett case and we're talking about zoning in this case. The point that the Florida Supreme Court was making, and it's very clear in its opinion, was that it costs a lot of time and money to get these regulatory approvals. And when someone goes through the trouble of getting one portion of the parcel for one use and another portion of the parcel for another use, that's a very strong indication that we have a disunity of use there, because it takes a lot of time and trouble to undo that. So if you wanted to sell these properties together as one master plan, for example, 114 acres as opposed to the 104, you'd have to go back to the regulatory authorities, spend the time and money to do that.
You could certainly sell the entire unit without backpedaling on the zoning, right? I mean, if your marketing strategy is, I can sell this as one parcel and I can get more money if it has a commercial section and a residential section, et cetera, then that might be a justification for getting different zoning, even if your intent was to treat it all as one unit, right?
Well, that's true. But for the test in terms of what is the parcel that's being condemned is a question of whether there is a unity of use between the two.
I guess the same could be true in Jarrett. I mean, that owner could have maybe intended to sell, whichever way was better. I'll sell all three together or I'll sell them separately. I mean, how would that affect the use? I mean, it's still platted for separate use in one case, it's still zoned for separate use in this case.
Right. And so the intent of the owner in the Jarrett case didn't matter. What mattered was that the owner had gone through the trouble of getting the regulatory approvals to plat these properties as separate pieces of
If the owner had bought this property with the zoning already in place, one part commercial, one part residential, could you have a parent tract in that case? Or is the difference in zoning determinative?
I think the difference in zoning would have been determinative. And I think it goes, what the law is trying to do...
So the fact that the owner went through a lot of time and effort and expense to do it isn't what's important. Your position is it your position that whenever there is a different category of zoning, there can't be a parent tract that is zoned differently than the subject tract?
when the parent tract is zoned differently from the subject tract, you have a disunity of interest. They cannot be the same parcel.
You never have a parent tract whose zoning is different than the subject
I
tract.
think I hesitate to say never, but I think it would be very, very difficult. I mean, when you go through all of the factors that the courts have decided, and there are about 10 different factors that are identified in the Jarrett case and the Jupiter case, you can see that all of those factors.
You could have a question of fact. I mean, in this case or another case, the testimony could be, yes, it's zoned for separate use now, but we intend to change the zoning, and this is our plan for the property, and we intend to use it as one. Then you would have a factual dispute, I mean, as to what the intended use was. I mean, But
you don't have that sort of factual dispute here. You have an owner in 2007 taking two different actions. One, the owner as to the bottom 10-acre parcel gets commercial zoning, and then at the same time in 2007 establishes a planned urban development over the top 104 acres and chooses not to include that bottom 10 acres. That's very strong evidence of the owner's intent. Evidence of the owner's intent, of
The
course,
owner
that
can
took place
also intend
before
to
this
say that we want to
condemnation.
use that bottom 9.9 acres as an attraction to sell the rest of it, so we can develop it commercially, and that will be an attraction for us to be able to sell the rest of the parcel in the back on the parent tract. And so we want to use that as a marketing tool to sell the whole thing. I think opposing counsel, if I understood his argument right, was that's what they wanted to do from the very beginning, sell all of this and use the commercial part to develop as an attraction to help them sell the rest of it. So the intent was, and the use was, for them to be able to sell everything and make a profit, make some money.
Right. Then that begs two questions. If that's the case, one, why in 2007 at the same time didn't they include that bottom 10 acres in the PUD?
He said
And
there
number
was
two-
no need to if it was going to be commercial, and they wanted to use the commercial aspect in the development as an attraction to sell the rest of it.
But if
Why
you-
would they need to do that then?
If you're going to argue that there's such interdependence between, and this is the question that we're asking here, is there such interdependence between the 10-acre parcel and the rest of the PUD that they have to be considered as a single tract? And the answer to that question is no. And they proved that themselves by leaving the 9.99 acres out of the 100.
Yeah, no, that bothers me a lot. I mean, to me, that's an important factor, but still, I mean, if we're looking at the intent of the owners and what they're going to do with the parcel, and that's a fact that we need to consider. I mean, we would have to consider the testimony of the owners as to what they intended to do with it, and it's to use the bottom commercial part as an attraction and as a selling tool for the rest of it.
But again, I think it begs two essential questions. One, why wasn't it then included in the PUD? And then secondly, the question that you asked, Judge Palmer, which is, then why did the expert come up with this highly artificial 53-acre parent tract that has nothing to do with the overall PUD? There's just nothing in...
Looking at the case law, your position is that when we're talking about what encompasses the parent tract for purposes of severance damages, that's always an issue for the trial court to decide. Even if it's a factual issue, the trial court has to decide.
Jarrett tells us that, yes.
All right. And then you can get up and, I guess we articulate your position that it's always the jury question to decide that.
But I'm also...
I have to go back and I have to read this case law even more closely now because you got two polar opposite positions and they couldn't be more extreme.
Right, and as I said, we think the Florida Supreme Court, looking specifically at the federal cases that reach exactly this question, has already answered that question for us. But our backup point is just as strong, which is on these facts, when there's no dispute about the zoning and the PUD and the separateness of these parcels, that this could be decided as a matter of law by the judge, even if you disagreed with our first position. I want to make a point that kind of touches upon a question that you asked earlier in the argument, Judge Lawson, which is, what happens if you own the PUD property and I own the 10-acre commercial property? There's absolutely no doubt that you cannot ask for severance damages. You can't. And so the law is looking for consistency. It wants to make sure that we have the same result that takes place when one owner happens to have compiled a number of parcels together. And so the law, even though one owner owns more than just that 10 acres, the law says we have got to look and see which of these parcels are so interdependent that they have to be considered a single lot. And how do we do that? We do that in a case where one owner owns both of them by looking at the unity of the use. And here, there could not be a more clear set of facts that there is absolute disunity of use, and that disunity of use was created by the owner himself when he zoned the bottom 10-acre parcel as commercial in 2007, and at the exact same time established the PUD for the northern 104 acres without merging them together. If the owner had in fact established a 114-acre PUD here in 2007, our argument would be tougher. But the owner didn't. The owner himself created that disunity of use.
A question that doesn't, I mean, this is tangential, I know it may not affect the legal issue, but it just seems odd that there would be a claim of separate, that the taking is on the far side of a
The bottom
10-acre,
15 acres,
the bottom
right.
15 acres of a commercial piece of property, and there's a claim of no severance damages for the remainder of that commercial property, but then skipping over that, there is severance damages for the residential, and there's no explanation in the briefs as to what the basis for that is, and it doesn't make any sense to me as to why that would be true. What was the explanation for why there was no severance damage calculation for, there were no severance damages claim for the rest, for the part?
Frankly, there was no explanation for that. My assumption is that since this was commercial property, they decided that the 3 poles on the southern 15 feet wouldn't affect the commercial property, but they would affect the sightlines for the residential property. But that was certainly not clearly articulated in the expert's report. Let me just very quickly take you through the factors that the Jupiter cases we should look at. It says, first, in unity, you should look at the intent of the owner. Well, we've seen the intent of the owner here in the conflicting regulatory approvals, commercial on the bottom, the PUD on the top. The adaptability of the property. This property is not readily adaptable now because of the commercial zoning in the PUD in the top.
Back to the intent of the property, wasn't there evidence of another intent, though? Wasn't there evidence of an intent to sell it all as a package?
There was evidence, again, both the expert and in their response, they say they might sell it all, they might sell it in phases. They never said that this property is so dependent that it has to be sold together. And I think that's the test that you would apply to determine whether these properties are dependent. And there simply is no evidence of that intent at all.
So what was the intent of the parties, in your mind?
The intent of the parties was to establish differing uses for the 2 parcels. The bottom 3 parcels that comprise the 10 acres have a commercial use and the highest and best use of commercial. The top 104 acres is established as a PUD, completely different, which is basically residential in the southern portion. So you've got residential in the south, commercial below that. There's simply no unity of use. I see that my time is...
No, but I do have one more question. I'll give opposing counsel a little extra time. Getting back to this issue as to whether it's a jury question or whether it's a question for the trial judge. Your position is it's a factual question, but the trial judge always decides it rather than the jury. And I think you argued that the statute says that the jury decides damages.
Solely the issue of compensation.
All right, and so your position is that if that's the case and the jury only decides the issue of compensation or damages, that it's the trial judge is supposed to determine what's the parent tract and whether there are there's anything in terms of severance damages for the jury to decide. Is that right?
Exactly. That's what the Jarrett case says in its footnote, and that's relying on a number of cases from across the country that have interpreted the similar federal statute to reach exactly the same result.
All right, but the question is then, why couldn't the issue of damages encompass what's the parent tract and what's not? I mean, why wouldn't that be a basic component of determining what the damages are?
Well, there are a number of legal building blocks in every case that have to be determined before you get to the actual issue of the numbers. I think what the statute is saying is that the jury decides the numbers. Once you determine what the tract is, the jury listens to the experts, decide the numbers.
This counts numbers. That's it. They just look, what's the damage, add up the figures and gives a number.
And the federal cases have grappled with that question question precisely, and they have said that because in the federal courts, just like in this court, where the rule says that the juries decide only the issue of compensation, that means the trial judges, not juries, decide that legal predicate, which is the scope of the Parent Track.
Okay. All right, thank you. And you'll have an extra minute and a half if you want it. That's up to you. Let me reset this, and so...
Your Honor, just... Thank you.
Okay.
Judge Loya, let me address your question real quick, and you mentioned you need to go back and read the cases. You're not going to find any cases that support this position. You're going to find one footnote in Jurek, which, again, as Judge Lawson pointed out, is, by their contention now, so obvious as to what it says, that not one case in 27 years has interpreted it that way.
But I do think the federal courts take kind of a different...
They do.
A different view.
No doubt.
In any event, getting back to the statute says the jury decides the damages.
Absolutely.
Why doesn't it...
Compensation.
Compensation.
I agree with your point. And again, juries are taking expert testimony and determining all sorts of factual issues that go to the issue of
The argument can
compensation.
go both ways. I mean, his argument is that if the jury's only to determine what the compensation is, or what the amount of the damages are,
Right.
That it would be for the trial court to determine the basis for the jury to make that determination, which is is this part of the Parent Tract or is it not? And that would seem to make sense if we look at the statute that way.
Again, nobody's looked at the statute that way, and I disagree with you on that point, because, again, there are necessarily factual determinations a jury has to make in determining compensation. If we're talking about flooding on the property, they hear from different experts and determine the impact of this, and is it real, and how much are they going to do. Their own brief at page 2 says, defining the scope of the Parent Tract necessarily defines the scope of the severance damages an owner is entitled to. So it is an issue of compensation. It is an issue of damages.
But his position is, and I think it's a pretty good argument, is that if the jury's is only to determine the amount of compensation, let's just the amount of damages to make it easy, then all they do is just they come up with a value and render a number that they think is the appropriate value or is the appropriate amount of damage. But in order for them to come to that, the trial judge has to make the decision as to whether this is the Parent Tract or whether this is separate and whether it's a continuous.
And I understand the argument, and perhaps federal courts have accepted that argument, but no Florida case has ever done that. For you to make new law and change the way that this case, that jury's been interpreted for 27 years is beyond the bounds of what this court should do. It's contrary to the two prior opinions of this court, which sent it back for factual determinations, and again, Judge Palmer was on that panel. It's contrary to the third DCA in Middick, and it's not, Jurek doesn't say that. And so I think if we go back and just look at that issue.
Let me ask you this. So, back to my practical question. I mean, it just is so odd. I mean, there's no question about the value of the property taken. So the compensation amount for the value of the property taken is settled and that's done.
Right.
And then there's a question about the severance damages for the piece of property that's adjacent to the property taken.
Right.
And the opinion is no severance damages.
And Your Honor, again, it is odd.
There are severance damages
Right.
for property further away on the other side of the commercial property. I mean, to me, is there any other explanation but that it's a different use?
No, Your
There are
Honor.
severance damages
No.
for this property because it's a different use, it's commercial, but you're claiming damages here because it's a different
Again,
use, really, it seems like.
Again, Your Honor, it was an expert opinion that was brought about, but I think, if I can, I'm running out of time on this, but I really want to make one final point on this. Factually, if this case were a summary judgment case, which it wasn't, this court couldn't affirm a summary judgment for a variety of reasons. The court in Jurek says it is a factual determination. You look at these factors. 2 of the 3 are undeniably in our favor. The third one talks about unity of use being the most important factor when it's unoccupied or not used. They admit it's unoccupied and not used. It's not the most important factor here. Finally, in Middick, out of the third, despite having unity of ownership and contiguity and platting, and again, it's critically important for this court not to conflate zoning with platting as they're urging you to do. The court in Jurek did not say that zoning and platting are the same thing, and they are very distinct and very different and much, much more involved in platting phases. And that's why there's a presumption that arises in platting that doesn't arise in zoning that still can be overcome, and you're still allowed to put on testimony to the jury to overcome that presumption. That's what Middick says, and that's what this court has found in those 2 cases.
Okay.
Thank you very much, Your Honor.
We'll argue on both sides. You both did a good job. Thank you.